Hearing from whom?
Item number 1.
My Lord, this is the appeal.
What is this, Mr. Chanaso?
My Lord, the writ petition filed by the appellant was dismissed by the learned single bench, saying that writ is not maintainable, and number 2, on merits of the case also.
Not maintainable, why?
Saying that perhaps a single bench did not elaborate, but refer one judgment. I also relied one judgment, and the respondent also relied one judgment. I will try to distinguish the judgment relied by the other side. My humble submission before the learned single bench was the Women College receiving grant in aid. Though in my post, they are not receiving, but remaining departments, they are receiving grant in aid.
To writ jurisdiction?
Yes, writ jurisdiction.
Yes.
And number 2, the ground of dismissal, determination to the writ appellant was wrong, because the Department of Computer Application or Department of Computer Education still remain in the college. Before.
No, meaning? No, just what are the background facts?
Who's
Who's the appellant?
My Lord, appellant is an assistant professor.
Okay.
Now, in 2011, he was inducted inducted as a lecturer, initially in the class 11 and 12, to impart computer education to the class 11 and 12 education. And later on, the college also introduced short-term skill-based courses for degree students, computer, like other Edmonds, Anthony's, they introduced. Now, in the college here also, in other colleges, there are 3 types of posts are there. One is a grant in aid post, either UGC scale or state scale.
Well, one short question, is this post, is it a sanctioned post?
It is a college sanctioned
post.
post.
Which you're serving against?
Yes, it is a college sanctioned post.
Okay.
And the third one is the ad hoc case lecturer. I take the plea that my case is a college sanctioned post, not a grant in aid sanctioned post. So I was appointed in 2011 for class 11 and 12. And later on, since the college also introduced for short-term courses for degree student, I was also allowed to teach as a lecturer for degree student. Now, in 2017, there was a change of nomenclature of the post from lecturer to assistant professor by the UGC. Now, the college governing body also adopted and followed that one, and my designation also changed from lecturer to assistant professor. Now,
one thing, when court asks a sanctioned post means whether if it's a grant and aid college, whether that post is sanctioned by the state department, or state government.
State government.
It's not sanctioned by state government.
In my case, it is not a state sanction.
Yes, who's appearing?
It is a college sanction.
I'm appealing for.
Lordship, I appear for respondent number 3, 4, and 5, Your Lordship.
You have received notice?
Yes, we have, sir.
Have you been served notice?
We are on caveat, Your Lordship.
Lordship, it appears there is caveat also.
Discharge the caveat, then we listen for admission hearing.
Lordship.
Come prepared.
Yes.
Yes. Or otherwise you won't have it today.
We can have it.
Anything. Next week or anything.
Okay. Seen a caveat petition number 49 to 2024. Filed by who's the caveator here? Caveator is?
Women's College, Your Lordship.
Caveator would be, my Lord, respondent number 3.
The principal Women's
4
College.
and 5.
Lordship.
3, 4, and 5. Respondent 3, 4, and 5. Women College,
the caveat,
principal and governing body.
Preferred by the respondent number 3, 4, and 5. Caveator has been served. Caveat stands as charged. Yes. Next, on the main case, heard Mr. H.H. Senior Counsel with MS E1 Young for the appellant. Stop the respondent number.
Lordship, I'm for
3, 4, and 5, Your Lordship.
Oh, yes, for you.
1 and 2, Your Lordship.
1 and 2, Mr. N.D. Shulailan, AAG with so-and-so is present. We have respondent 1 and 2.
Lordship.
You. MS S. Salam is present for number 6. MS A. Paul on caveat is present on behalf of 3, 4, and 5. What about 7?
Lordship, notice will have to go.
Notice to go to respondent number 7
Lordship.
within 3 days. This is a matter of 2 weeks for admission hearing.
Lordship.
We'll try this call of next day.
Well,
Lordship.
You come prepared.
Apply, Your Lordship.
Lordship, the limited matter is that this the case of the petitioner is that he has not been appointed in this very college. and the very department does not exist, Your Lordship.
Fine, we'll hear you. Like, we'll hear you. We'll dispose of next
Lordship.
date. Yes.
Lordship, obliged.
Hello.
Any mention?
May it please, Your Lordship. Lordship, I beg to mention item number 16.
Number?
Item number 16, Lordship. The learned DSGI is indisposed.
What happened to him?
He's not well, Lordship.
Indisposed means not well.
Yes,
Hope not
Lordship.
seriously indisposed.
Fever.
Yes, Mr. Chanda.
Yes, my lord. Since he is indisposed, my lord.
16, you're there, 16.
16 is with Sir M. Chanda and 17 to 20, Lordship, is Sir
17 to
Pathak.
20.
These all are connected matters, Lordship.
17 to 20.
16 to 20 are connected.
When?
After 2 weeks, Lordship.
2 weeks.
Yes, my lord. Yes, my lord.
Okay, 2 weeks. Yes.
Highly obliged.
Obliged, Your Lordship.
16 to 20. 16 to 20.
Lordship, I beg to mention item 22, Lordship. Item 22. Respondent 1, 2, and 3.
What's happening? Yes?
Item number 22, Lordship. I pray for an adjournment of 2 weeks on behalf of Respondent 1, 2, and 3, Lordship.
What is the problem?
Need some time for preparation.
Nokma matter?
Nokma matter.
You ready?
Objection. No, Lordship.
Item 22.
Okay, 2 weeks.
Obliged, Lordship.
Your Lordship, I'd like to mention item number 26, Your Lordship. Mr. Subhas Kayal, he's admitted in hospital in Guwahati, Your Lordship. So he'll be going for further treatment and he'll be back by 5th. So he had instructed me to seek time till after the 5th of July. So he'll be joining.
So that'll be 3 weeks.
Yes, Your Lordship.
3 weeks will cover, no?
I'm not sure. Could be after 4 weeks, no problem.
Yeah, it'll be after 4 weeks, yes.
Gotcha. Obliged.
As the arguing counsel for the petitioners will be unwell. It's a matter of the 4 weeks, yes. Unwell and under treatment. It's a matter of 4 weeks, yes.
Obliged.
May it please, Your Lordship. Your Lordship, I beg to mention item number 27 on behalf of Ms. P. Agarwal for the state respondent, Your Lordship.
Who's there for the petitioner? Why is he adjournment?
She's not well, Your Lordship.
No objection. You have any objections or not?
No, no.
How long?
2 weeks, Your Lordship.
Yes.
Obliged, Lordship. Please, Your Lordship, I beg to mention item number 25. 25, Your Lordship. The conducting counsel, he had to go out of station in the morning, Your Honor.
Who's Mr. Conducting Counsel?
S. Kumar, Your Lordship.
No objection, Your Lordship.
1 week.
2 weeks, Your Lordship.
And you clog up the list 2 weeks, yes.
Any-
Daily list, item number 1.
May I please, Your Lordship?
Yes.
The conducting counsel is indisposed. Ms. P. Agarwal, she has a severe migraine attack as a morning. So kindly attend this
Lift
matter.
up to 1 week, 1, 2, and 3. As the counsel, the petitioner is indisposed, yes.
Obliged, Your Lordship.
Stated to be indisposed, sorry.
Lordship. Obliged.
Yes.
Supplementary list, item number 1.
Please, Your Lordship. I filed one miss case seeking 2 prayers. One is deletion of one of the respondent number 5, and in the red petition, and also for impleading necessary parties. Your Lordship. Reason being for deletion is on the submission made by one of the respondent, that is respondent number 5, who had submitted the respondent number 4, who had submitted the respondent number 5.
Where's,
are already
who's
expired.
respondent before?
Respondent number Mr. Sage Maulang.
Where's he
So
today?
I could not serve this copy because all this past week
Then you have to give copy first to him.
I understand, Lordship, but
Then we have to issue notice. We serve copy to him.
this matter is fixed on 27. So before that, I'll try to, because he's coming on 27 to file affidavit.
Miss case 99/2024 is an application seeking deletion of the name of respondent number 5 and for insertion of how many respondents in this place?
I'm 7.
7 are respondents in his place. Are his successors?
No, not in his place, but to implement
for the
others.
7 respondents. Are you sure they're all alive?
Yes, they are correspondent. It's just because of the letters and correspondence between the respondent number 3 and these people.
As a counsel, respondent number 5 or 4, there's a present Lisa's matter on 27.
27.
Petitioner to serve
Before that.
the Mrs. application on the said respondents is
Lordship.
Daily list item number 4.
Your Lordship, we are yet to receive instruction from the petitioner for filing rejoinder, Your Lordship.
Then we'll close rejoinder. How many times is what time?
Fourth time.
Yes, MS PJ3 submits that. PJ3, correct?
P. Sunar.
Sorry. Submits that instructions have not been received regarding the rejoinder. Stop. It is noted that several apologies have been granted to the petition to file rejoinder. Accordingly, filing rejoinder is closed as a matter for hearing. Yes.
Number 2 and 3 are yet to enter appearance.
2 and 3 yet to enter appearance? How come?
Respondent 2 and 3 are the private. They were supposed to. The last order says it's fixed for appearance of.
No, it says as per 2 weeks time granted for rejoinder affidavit.
The order of 10th of May, Lordship.
10th of
May. 10th May.
Yes, this is matter for hearing. If no appearance is made on behalf of the respondent 2 and 3, the same shall proceed ex parte.
Bless you, Lordship.
Item number 5.
Lordship, I've taken step on respondent number 6.
Yes?
Lordship, I've already taken step on respondent number 6.
You're appearing here?
Yes, my lord.
What's the matter about?
This is regarding diploma of 18 months, my lord. The teachers have already been appointed. They are working, and the
There's no
counter has
interim
already
order?
been filed.
Are the interim orders?
There are no interim orders, my lord.
Yes. Been served upon 6 no.
We are representing respondent number 1 to 5, my lord, but there are private respondents also.
Only one respondent. Only one.
6 to
Only on
19.
6. 7, 8, 11, 14 should have been struck off.
Yes, my lord.
Correct.
Yes, Lordship.
How many remain?
9, 10, 12, 16, 17, 18, 19.
They've been served.
I've already taken step for the second time on respondent number 16 to 19.
They've been served or no?
Lordship?
They have not been served as yet.
Have they been served?
Lordship,
They've been
we
served.
have to get the status report. Lordship.
I am appearing for respondent number 6, my lord, NCTE.
NCTE.
Yes.
Okay, so good. What's your name?
My lord, TSK. On behalf of Mr. Ayalom and sitting.
TSK?
Yes, my lord. TSK, my lord.
What's your full name?
Taizuddin Sheikh, my lord.
And what do you mean by TSK?
My lord.
You think is that popular that every country will know by abbreviation?
Sorry.
Yes.
Taizuddin Sheikh, my lord. On behalf
Mr.
of
So-and-so has entered the vice. Vice? Mr. Who's you appear on whose behalf?
my lord, Mr. Istiaq Alam, Standing Council, NCT.
Yes. Istiaq Alam is standing counsel is the petitioner is
Yes, petitioner is yours.
same name.
Same name, same
There is
name.
some spelling, my lord, difference.
How's your Istiaq Alam spell?
My lord?
How's your Istiaq Alam spell?
ALAM.
ISTIAQUE, my lord. And this is my lord. Okay, my lord. Right?
Very strange, kind of funny names. Yes. Right, Mr. Yes, Vice, Mr. You take the correct name. Yes, entered appearance on behalf of respondent number 6, NCTE today. Stop, Mr. S.E. Sheikh is entering appearance today. Is present on behalf of respondent 12. What about the other respondents?
Bring that I may be allowed to file service affidavit.
Ms. Iwanyang submits that on regard to other respondents' status report. You still awaited, or you didn't ask for status report?
Lordship, we still have to
obtained,
apply.
yes, with regard to service, yes. List this matter after?
2 weeks, Lordship.
After? You want to file affidavit?
My lord, we will file my lord.
Yes, this is the matter after 2 weeks. Meanwhile, respondents number 6 and 12 to file affidavits.
You oblige.
Date you take my court, master. Yes.
Item number 6.
TSK.
I humbly pray, Lordship, if you may kindly take up this matter after 2 weeks, Lordship.
At another board?
After 2 weeks, Lordship. We are awaiting instruction.
No objection, Your Lordship.
What's the matter about?
It's a pension matter.
Pension.
First wife, second wife?
Has to give the
life certificate.
records of the pension.
Yes, MS Prathan submits this matter be taken after 2 weeks to enable the respondent notified to obtain or enable to obtain instructions. Yes, there are. That's one.
This matter, some miscase has been filed, which I haven't received the copy of your miscase.
Filed.
What miscase has been filed?
Filed by the respondent, Your Lordship.
Lordship, we have filed this miscase, Lordship. Application for striking out the names of respondent 1, 2, and 4, Lordship. On 17th May.
In the miscase, same thing. List together with the main case as instructions yet to be obtained.
Obliged, Your Lordship.
You gave a copy to
Item 7.
your respondent number?
6, 7, and 8.
You want copy here.
Item 7.
Your file?
I filed my counter.
Yes.
Your Lordship, we already received one affidavit filed by the respondent number 2, and respondent number 1 and 3 are yet to file the affidavit.
You already filed, you said, for 1 and 2.
Lordship, the state 1 and 2. Only 3 is accountant general, Lordship.
It's already filed, he said. Yes,
One to have
MSSC Sheikh submits that affidavit on behalf of respondents 1 and 2 since been filed. Top MS EB Pasa for number 3 submits that the affidavit will be filed in the course of the day. In the course of the?
Within a week, Lordship.
Let's say that within a week. Yes, within a week, yes. List. You want to file rejoinder?
No.
What's your name?
Orius Sinclair.
Is the first time you're appearing?
Yes, my lord.
Very good, yes. List after 2 weeks for affidavit by respondent number and for rejoinder if any to the affidavit of respondent number 1 and 2.
Item number 8.
Please, Lordship. Lordship, I'm praying for 1 more week, Lordship.
You want to withdraw it?
Third time
No,
they have filed the rejoin.
1 week,
Wait for
Lordship,
time.
we'll be filing. Give 1 more week, Lordship.
What's wrong, Mr. Paul's chamber? Everything is slow motion. Or there are too many layers of permission they have to go through.
This is the fourth time, Your Lordship.
Fourth time asking?
Yes.
Then rejoinder is closed.
Lordship, give us 1 week, Lordship. At least it's ready, Lordship, but there's some correction to be made in the rejoinder. That's all.
Rejoinder is not a matter of right. This is the fourth time you're asking for. It's the fourth time. Mr. Snaitang fairly submits that though this is the fourth time he's seeking, this is the fourth occasion he's seeking time for rejoinder. He prays be given 1 week's time as a final opportunity. Stop the request is denied. This is a matter for hearing. However, we shall be able to file rejoinder in the meanwhile. Yes.
Item number 9.
Yes.
Your Lordship, I am for respondent number 3, and kindly grant us 2 week time to file affidavit, Your Lordship.
They are taking time, my lordship. Some of my petitioners, they are going to retire very soon. One is going to retire.
Pension matter?
No, it is a regularization matter.
You against new?
Yes, Your Lordship. Respondent 4.
You file affidavit?
They have not.
You won't file?
We will be filing, Your Lordship.
4 and 5, PR for 3, you have VGC. What about 1 and 2? MS Pradhan submits that since they are formal parties, no affidavit before coming from respondents 1 and 2. MSP Agarwal, you pray for more time. What's your name?
2 weeks time, Your Lordship.
What's your name?
BJ Das.
Bhaskar
Jyoti Das.
Okay, Mr. BJ Das, Vice Dr. P. Agarwal for respondent with 3.
Your Lordship.
Salam for 4 and 5. Pray for loud for the 2 weeks time to file affidavit. Yes.
Much obliged.
Item number 10.
Your Lordship, I filed the affidavit yesterday on behalf of respondents 1 to 8.
What about service report on 9 to 11, 13, 15, 19, 22?
Lordship, I will be filing status report.
What is your name? Haring?
MR Marak, Lordship.
MR Marak. Mr. MR Marak. Office note indicates that service is not complete with regard to the respondents number 9, 11, 13, 16, 17, 18, 19. Right, 9, 11, 13, and 16 to 19, 22 and 23. Service. 23. Mr. Marak prays he be allowed to obtain his report to file affidavit. Stop next line. MSZE now can be for respondent number
1 to 8.
1 to 8 submits that affidavit has been filed.
Lordship, interim order may be continue.
Yes?
Interim order.
Interim order?
Yes, Lordship.
Interim order will continue next day. Just after 2 weeks. First list after 2 weeks, interim order continue.
11. 11.
Please, Your Lordship, bring some more time to file the affidavit, Your Lordship.
What's the matter about?
Pension matter.
Last time nobody appeared. What's the matter about?
Pension matter, Your Lordship.
Pension matter. When did the writ petitioner retire?
On
31st
March
2024.
Yes.
31st of?
March.
24.
Yes, Your Lordship.
How much more
2
time?
weeks, Your Lordship. 2 weeks.
Mr. Rinja prays for God for a 2 weeks to file affidavit on behalf of respondents numbers.
State respondent, Your Lordship.
How many number? You want to file with you?
It's with H. Karwanlang, Your Lordship. It's in this post.
Item number 12.
Lordship, the state respondents have filed their affidavit yesterday. Oh, I'm so sorry.
Yes.
No, please, Your Lordship. They have filed an affidavit, my lord. It seems like this matter can be disposed of, my lord, in view of the reply which they have given at para number 14.
What's the matter about?
It
This for
was
pension, my lord.
regarding pension.
This is a non-teaching staff, my lord.
Taken over by the district council.
It was taken over by the district council, my lord.
Okay.
So at para 14, Your Lordship, we have said that the department is considering the payment of pensionary benefits to the other non-teaching staffs along with the husband of the petitioner, which are lying for consideration with the concerned competent government authority. We seek some time, Your Lordship, to enable us to
What about other non-teaching staff in other schools, other council schools, which have been taken over by the Act 1994? Yes. There's a case there. There's one judgment I think passed with this.
Lordship.
There are two.
So far as the petition is concerned, my lord, they have already released it.
Oh, there are some judgments passed by this court only.
Yes,
Yeah,
Your
there are
Lordship, we are aware of
number
that.
of judgments,
Your
my lord. I've
Lordship
enclosed
has
it.
allowed, so we have not said anything against payment, but then they seek time to take proper consideration. His name is also in the list, Your Lordship.
And just to bring to notice of this Honorable Court, my lord, so far as one petitioner, namely Marina and Sama, there has been already released the pension and other retirement benefits, my lord, in view of the judgment passed by this Honorable Court.
So there are a number of such non-teaching staff whose matters under consideration. At page 19, Your Lordship.
Any affidavit?
They have filed, my lord.
My
19?
affidavit, Your Lordship.
19?
At serial number 2, Your Lordship, his name is there. Neferine K.
That is
Sangma.
number 2.
Yes, he has expired. This
He's
application
expired, ma'am.
has been filed by his wife.
Yes. Page 19.
Yes, Your Lordship.
There's so many non-teaching, not
Staff
non-teaching, I
taken
mean,
over.
Yes, my lord.
Non-government teaching staff, so many. Name is?
Neferine K. Sangma, my lord.
Neferine Sangma expired.
SI.
Appointed.
He was appointed
Oh, then
in
they were, he was by 93, the school was taken over 95.
95, Your Lordship.
He died in harness.
Yes, my lord.
Yes, take down. This matter is similar to other matters that have been brought before this court, which is with regard to the entitlement and payment of pension of the non-government teaching staff of district council schools, which had been taken over by the which act was that?
Meghalaya taking over of district council.
Where
primary
is the
schools.
petition? Is here?
Lordship.
At para 8 of the affidavit, Your Lordship, we've given the Meghalaya within bracket
Yes.
taking over of district
Para 8
council
of the
over
affidavit.
primary school Act 1993.
Yes, it's taken over by the government under the Meghalaya, in bracket, taking over district council, low primary schools, close bracket, Act 1993. Stop. In the earlier matters, as submitted by the councils, both for the petitioner and for the state respondents, consideration has been given and pension as entitled and pension as per entitlement has since been released. Stop. A perusal of the affidavit filed by the state respondent in this case also reflects the same position, wherein at para 14 it has been stated as follows. Go para 14. So, next paragraph. Mr. A.G. Mum, Leonard Counsel for the petitioner, submits that as the case is similarly situated with the other matters that have come before this court, the state respondent directed to the process within
4 months.
to expedite the process of consideration of payment of pension to the petitioner.
At least time.
Family pension.
Lordship. At least time frame may be granted, my lord.
Yes, so accordingly, matters disposed of. It's expected that the process for consideration release of pension should be completed within 4 months from the date a copy's order is presented for the respondents.
Highly obliged, my lord.
Lordship, I am praying for further 2 weeks' time to file affidavit in this matter.
Yes, what's the matter about?
Tender, Lordship.
What's the matter about?
Item number 13.
Yes, what's the matter about? In the case?
Matter refund application for performance guarantee.
It's for refund or it's for? Then the matter is for refund of security deposit. What is this? Refund on the aforesaid, okay.
Lordship, the petitioners were refused performance guarantee.
Yes. Your name?
M. Gogoi.
Yes. MSE Pradhan praised funds allowed further 2 weeks time to file affidavit on behalf of the respondents. Just thereafter.
Highly appreciated.
14.
Your Lordship, I'm praying for them to file an affidavit, Your Lordship.
The second time has come.
Yes, Your Lordship.
How much time?
2 weeks' time, Your Lordship.
And is it, any other respondents?
Private respondent, yes, Lordship. Yes, Lordship, there is private respondent.
How many?
2, Lordship.
They've been served.
Yes, Lordship.
They've served.
Oh, 3 respondent, Lordship.
Had he been served 5, 6, and 7?
Yes, Lordship.
How do you know?
No, we have taken steps, Lordship.
Taken steps and being served are two different things.
Okay, Lordship, I'll obtain status. So.
Yes, Amazon Nagari pays funds allowed 2 weeks time to file affidavit on behalf of the Department to stop Mr. Areng, correct?
Yes, Lordship.
Ellen Areng?
Yes, Lordship.
For the, with regard to the other respondents 5, 6, and 7, Ms. Ellen Areng please be allowed to file a status of indicating status of service. This list.
Obliged, Your Lordship.
Supplementary list, item number 2, hearing.
Lordship, I'm praying if you may kindly take up this matter after a week.
He's not well. Yes, as Leonard DSGI is indisposed, this is a matter up to 1 week.
Highly obliged.
Item number 15, daily list.
It's pertaining to, my lord, the appointment of Doloi. If your lordship recollect, my lord, last hearing your lordship asked me, my lord, to obtain necessary instruction with regard to a inquiry report annexed in their rejoinder, your lordships. Now, my lord, I have obtained some records.
Yes.
Well, that inquiry report, my lord, was prepared, my lord, after conducting an inquiry on 8 December 72 and January 73, my lord, 25th January.
Sorry, just come back.
So, my lord, I looked into the records of the district council for the relevant period of time. My lord, it's true, my lord, this is in the records. Now, what
What's
happened,
the
your
records
lordship,
there?
It is on the records, your lordships. The district council, my lord, directed for an inquiry by the revenue officer of the district council.
Yes.
Now, well, he conducted an inquiry and submitted reports. Now, well, this report, your lordship, was thereafter taken on records, and there is an order, my lord, ultimately, though, my lord, the CEM at that point of time, he expressed his opinion, but going by this report, going by other materials on records, it appears, my lord, even the Christians were holding the post of Doloi. There is no more, because it is the Lindo who was performing the customary audition. But then he recommended, my lord, the matter should be discussed by the EC.
It was never done.
Well, it was done, but then EC again, my lord, it is there in the records. Then EC thereafter again, my lord, directed for a fresh sort of inquiry. Fresh sort of inquiry, it is their records, and submit. So that report was also submitted, my lords. And again there was a, my lord, notings by the ECCM to place it before the EC. Now, my lord, ultimately the decision, if any, taken by the EC, my lord, I am unable to locate that file. These are all pertaining to, my lord, 73, 74.
Do you have the other records?
Yes, other records, my lord. Those I can flag mark, your lordships. I will flag mark with this quite bulky, my lord. This is yellow. Start from contact. No, it is here, my lord. The relevant parts are here. I don't know, there are many flag marks. Lordship need not go into all those things, my lord, only the relevant part. If Lordship permit me, my lord, I'll make it in a better way, flag marking, so that Lordship can identify conveniently.
No, because we need a proper inquiry into the whole matter.
Exactly.
Because in view
Exactly.
of,
All those notings are there. I'll do it in a better way, my lord, so that Lordship can easily identify that, my lord. And I'll submit it. So this is what, my lord, I looked into, my lord, this is what. But ultimately, what decision they have taken, my lord, I try to locate, my lord, unable to do it.
So there's no conclusive.
At least the record, my lord, I could not lay my hand on the record.
Conclusive finding of fact, that means on.
My lord, so far with records.
That will make the job of the court easier.
Lorships. So, my lord, this is one thing, but the facts remains, my lord, from 75, my lord, which we have placed in our affidavit in opposition, 75, my lord, till 19, except for a very brief period, my lord, all throughout the position has been held by a Christian. Now, it's almost 50 years, my lord. Now, 50 years, my lord, it's not that we are not saying, my lord, it is our prime duty, my lord, to preserve the custom of the Niyamtre, my lord, the indigenous custom. Now, that, my lord, we are doing it, it's the Lindo who is performing. And if your lordship, my lord, I'll say, my lord, this entire case has been inspired by the decision given by the Supreme Court in that Juai Alaka.
Even then, see, looking into the historical aspect, regarding even of restoration of customary practices, because a lot of them have been diluted, and they've been because of the dispensation that is there in the state, which is Christian majority. So in many traditional institutions have been diluted, like even Williams, Imship, and this and that, where especially with regard to rituals and all. So before, what was practiced before, and what is come now, because diluted by the action of whatever who were at the helm of the State Council and all, which allowed this erosion of customary practices and all. So that is we have to, of course, look at that also, whether there can be any kind of restorative, action again, if the court can at all take in that kind of thing. Looking, taking a deeper inquiry into the practices that are there, because that's the thing. What we cannot close our eyes to that fact also. No, we have to look at the customs that are practiced and whether it's practical. If it's practiced, it's practicable, then yes, let it go on. But if if we talk about restoration or maybe facilitation, then we have to look at that aspect.
No, but here one thing, my learned friend is saying that we are not concerned with it. This is our constitutional obligation. Lordship, one thing I can just point out. Now, what happened in the Juai Alaka case? Juai Alaka case, it is the district council, my lord, we pinpoint, and we say, my lord, it is the Dole has to be a, my lord, indigenous.
It's a different footing. You see, just to draw an analogy, the other Ilakas elsewhere. Now, what has happened is that there's some practice that have to be done. It's supposed they have these Rajs, right? There'll be 3-4 of them. Now, in 1 or 2 Raj, this is practicing customs and all, which is supposed to, the Sardar or the Lingdo of that area, or the Sardar, is supposed to, to facilitate them, to make them happen. And what has happened is that if he has converted, then he starts, what he does is that instead of propagating them, then the sort of suppression takes place there. Right, those things are not allowed to happen. It's happened in Kong Thong and everywhere. Like that. It's not allowed to happen. And so what happens, there's a lot of, dissent, and, so we have to look at, via media where these practices are maintained, whether it be a Christian Lindo or something, that he has to ensure that, what's practice should carry on. That's the thing.
But here, my lord, at least, my lord, I'm right now concerned with
Rimbai. I'm not saying that. Maybe a situation exists here.
No, my lord,
that's
the
thing.
It's true, my lord. But here, my lord, if you mention Rimbai Alaka, my lord, based on materials on record, I filed an affidavit. 50 years, my lord. There is no confusion, no chaos. Nobody has come forward that we are not allowed, my lord. The customary practice was not enforced. 50 years it was continued.
We have filed many complaints, my lord, in between.
No, we'll go into that. I mean, it doesn't mean that just because, if it's in practice, if it's all right, if the people are happy, and the practices are not affected, then there's no need to, to pass any orders to, to see, okay, fine. But then if, that's the only thing.
There's other thing, my lord, lordship can take guidance from the Supreme Court judgment. Well, I have very carefully gone through this judgment. There, in that case, it is the district council notifying the election. Candidate should be Niyamtre. Specific. Now, that was challenged by some secular front, my lord, from some association. They challenged it cannot be in a secular country. So, matter ultimately went to the Supreme Court. Now, there in that case, my lord, that association, they placed on records, there were 2 occasions. His side Dolois were appointed in Juai. Now, court went deep into the matter, my lord, with the reference to material. Now, they found, my lord, on both these occasions, my lord, there was hue and cry. And both these persons were forced to resign, or district council had to take to terminate. So, what the ultimately Supreme Court said, these two instances, these can be at best aberrations. Custom has never discontinued. So, here my case is, my lord, 50 years, my lord, 50 years.
No, that is a different footing also. They use Article 16 also. They said that the law is an administrative office. You know, that is, that we are aware, yes. That's
So, my lord, this is the place, my lord, this I will place, my lord, with relevant marking.
You have to show that, you know, that the maintenance of custom and has not been affected, how it is carried on, that's all.
Now, our stand is, my lord, it is the Lindo, my lord, who is performing. And, my lord, initially that 1959 Act, my lord, there was no provision, my lord. There was no provision for a customary functionary. Now, these acts since have been replaced by an act of 2015, your lordship. Now, 2015, we have elaborate provision for a customary functionary.
It's like not Doloi, right?
Yes, Doloi. Now, customary functionary, why? Because we have found out, my lord, in different ilakas, my lord, is the Lindo who discharges. May not be all. Say, for example, Juai is the Doloi himself. But there are other places where the Lindo, my lord, performs the customary.
Oh, that's correct. In many Doloiships, the Doloi is like is a Christian. There's no problem.
So this is one of the reasons, my lord.
It depends because every custom specific to like every ilaka. Yes.
So, my lord, we have incorporated a customary functionary, and we are saying categorically. So, for this particular, my lord, ilaka is concerned, my lord, Rimbai ilaka, it is the Lindo who performs, and these facts stand substantiate from the fact that last 50 years, the Christians, Dolois were Christian, your lordships.
As I want to see is inquiry, because if there's some definitive finding there, then...
My lord, that's again, my lord, I looked into it. Ultimate final decision by the executive committee, my lord. I could not lay my hand into that record. It's quite old record, my lord, pertaining to 70s, early 70s.
My lord has...
Constitutional authority should maintain records.
My lord, I have tried my...
My lord has inquired about the inquiry report, and my lord, the original record is here. My lord can go
No, I'm not disowning this inquiry report. I'm not disowning it.
My lord can
This
go
is true.
through the record.
But then that report again, your lordship, will look at. That report, my lord, what it says, it referred to 4 or 5 Dolos who were, my lord, holding the post prior to the Constitution of India came into force. And one of the Doloit, my lord, after assuming office, my lord, he converted himself into Christianity. And he continued. So that shows, my lord, even before the Constitution, a Christian was holding the post.
But I know one thing, of course, to know is like, you see, what were the customs that are practiced, right? Whether all along that Dolai, what was his role? As happened at Iwan Linki case. Now, what is his role and what is his functions? Whether, you know, as per by the pattern that Eleka, the Dolai is a what do you call it, indispensable aspect of those functions. Or whether in some cases, like he says, the Dolai says, okay, fine, I'm not interested, let the Lingdo do it. So those are the things.
No, I understand. When your lordship is saying indispensable, that he
so
will
the
have
court's
to be...
going to look, it's not going to look here or there, it's going to look at, you know, like, what do you call it, at, what's the word, I can't get it. Anyway, it's look into the interests of, you know, of the entire Eleka. And if it is to pronounce, like, you know, like law or something, then it should be on the basis of, you know, a proper, you know, research and...
I mean, coming into the other aspects, my lord, so far my learned friend, my lord, he has some, my lord, writings with regard to the practice, my lord. He has annexed in this thing. Now, my lord, what are the authenticity of this thing? Because we are saying, my lord, so far this Elaka is concerned, my lord, the Lindo is competent and he has been discharging these functions, my lord.
No, that you're at liberty to rebut, that is no problem.
Now, other provision is regarding, my lord, there is a provision for puja land, which generates revenue for the purpose of spending for these customary practices. My lord, there is no disruption in this. That will have been done, my lord.
Now, puja land, who derives income from those recs? They call recs or puja lands. Who derives income from them? The income from puja lands or from those, what do you call it, Raj land, who takes income from them? The Lungdo gets them.
Yes, customary practice, my lord.
No, who gets it? Who gets it? Suppose income from puja land, it goes to whom?
It will go to the, my lord, Lindo, my lord, because he is the, my lord, he is the one who, because this has to be spent, my lord, only for...
Yeah, are you sure it goes to Lindo? The entire proceeds of that puja land goes to the Lindo?
Yes.
No, my lord.
Yes.
This goes to the Doloi as per the Act, my lord.
This is, my lord, we are not spending anything, my lord. So far, this revenue is generated, your lordship. This revenue is not spent for any other purpose, but only for the purpose of, my lord, following the...
No, it goes to whose pocket?
Collections, my lord.
The collection, yes. From Puja land, where does it go to?
That exactly, my
Because
lord,
there are
how
two types.
it is
There are two types.
rooted.
You see, there are two types of lands that are set aside customarily for Dolois, you know.
Service land and
one is service land, one is puja land. Service land for the services he renders because there's a remuneration for the service he gives the Ileka. And the puja land which is given, that's in the form of paddy fields and other, is given like so that from that, proceeds from there, whatever revenue gains is used for, whatever, that's the thing.
It's there, my lord, in section 2. Subsection 20 of the 2015 Act. It says puja land means a revenue-free land and held and cultivated by a doloi, sardar or any of the customary functionaries, and the yield or income therefrom is utilized for meeting the expenses connected with the religious performances according to customs of the ilaka.
Customary functionaries, again, your lordship, is categorically mentioned. That's why
So
he's
that
saying, my
means
lord, the
he gives
incorporation.
income gives lindo.
Yes. And that's why he says cultivation also, my lord,
You file
customary.
that, we'll hear it. It's interesting.
My lord.
You file those.
Record, your lordship.
Yes.
In the course of the day, my lord, I can submit it here or.
No, but it has to be collated in the proper manner to, like, you index it and you write what's the document about. You
But
write
I'll
small
file the
index.
original, my lord. Original record, I'll please.
You have to if you can give a
No,
small
this I can
index.
prepare an index along with this original records.
And my lord, 2015 Act, the preamble itself says that who is doloi, whereas the doloi sardar is the traditional customary chief. He is the chief of the customary practice.
Only the question is,
But if you see, we are going to look into what is time immemorial means when.
Right.
And whether whether there has been aberration or deviation also we'll see.
Yes.
That's the only thing. The records of inquiries held on.
Held on, my lord, 2 days, my lord. It was held on 8 December 72
Held on
and 25th January
8,
73.
12, 1972
And 25th January 73.
25th January 1973 have been obtained by the counsel for the GHEDC and produced in court today. Stop. He prays that he be allowed to present them again after indexing the same for convenience of the court. Stop. The prayers allowed be listed when?
After a week, madam. When to list?
After a week.
No, in the meantime, I'll keep it ready.
This matter after a week of further hearing.
Item 21.
All right.
Supreme Court's over.
No, my lord, this matter is still pending. What I saw the latest status, my lord. So, your lordship may have it after 6 weeks or so, because Supreme Court is having summer vacation also, my lord.
Lordship. Yes, the Learned Advocate General apprised the court that the matter is still pending hearing before the Supreme Court. Stop. Accordingly, this is a matter after 8 weeks. Yes.
22.
Was probably mentioned, my lord.
When it was mentioned, more matter.
23.
May it please your lordship.
1 second, slight disruption, because 22 was adjourned. They thought it was 23, so 23 file is sent back.
Oh, okay.
23 is one matter.
Well, regarding that MECL pensioners, that association.
But what the other matters were settled.
Yes, my lord. Payments are being made, my lord. Payments are being made.
Those
yes.
which have been filed by the individuals.
Individuals.
Now you got a huge tranche of money from central government. You
I
tap state government some of that.
I also saw.
The file's gone back to section.
Yes,
We can take it up a little later.
Yeah, take out a little later.
24. 24.
24.
24 your matter only.
My lord.
Just after your selection, you not selected.
My lord,
He was not promoted
Oh, sorry.
that promotion, my lord.
because he had not been regularized.
I'll take your lordship to that. Well, in view of the stand taken by the respondents now, my lord, I'll have to take your lordship to the annexures also, my lord.
Yes, start.
My lord, if your lordship comes to page 19, my lord,
Writ petition.
writ petition, my lord. So, my lord, by this office order dated 10/1/2003, my lord, the petitioner was given his initial appointment. Now, my lord, on the recommendation of the Departmental Selection Committee, Sri H. Khongam is hereby allowed to officiate temporarily in the post of lab assistant in the scale of pay of so much. He was given a regular scale of pay plus usual allowances with effect from the date of his joining. The appointment is purely temporary and is terminable at any time without assigning any reason thereof. So, my lord, no, it was not for any specific period, my lord. Appointment was on a regular scale and on a
Temporary basis.
Temporary, my lord, that is.
Departmental Selection Committee means like were there other people in contention also, or whether
Yes.
it's a single horse race?
No. There was a selection procedure. Selection process was there, my lord.
Okay.
Now, my lord, next, Annexure 2, my lord,
Yeah.
at page 21. Now, so-and-so is lab assistant is hereby allowed to officiate temporarily in the post of assistant chemist. So, this is one post higher, my lord. In the post of assistant chemist in the scale of pay of so-and-so plus usual allowances as admissible under the rules with effect from the date of his joining until the post is filled up by promotion or recommendation of MPSC. The appointment is purely temporary and is liable to terminate at any time without notice or assigning any reason. So, my lord, he was given a promotion, my lord, and that is also on an
See, HM is hereby allowed to officiate temporarily.
Officiate temporarily.
Not is allowed to. It's officiating only.
Officiating
substantive post, which is temporary, also still as a junior chemist.
My lord, he was just temporarily allowed to officiate, my lord. That is what. Now, my lord.
Oh, sorry, lab assistant. Yes, lab assistant.
Lab assistant, my lord.
Not junior chemist. Lab
lord.
assistant, then assistant chemist.
My lord. Now, my lord, next page, 22. 22, my lord. On recommendation of the Departmental Promotion Committee, held on 11 July 2008, the following persons are hereby allowed for regular promotion to the post of assistant chemist in the scale of pay of so-and-so, plus other usual allowances as admissible under the rules with effect from the date of joining. So, his name is there.
Yes.
So, my lord, on the recommendation of the department, this was a regular my lord, promotion which was given to him. On the recommendation of the, so my lord, thereafter he was allowed to cross the efficiency bar also, the next annexure, my lord. And
that was in 2008.
That in 2004, this was in 2008, my lord, that he was allowed to have regular promotion.
Yes.
My lord, then the next annexure, my lord, that he was allowed to cross the efficiency bar also. That was in 2014. So he has been working as an assistant chemist since then, my lord.
Since 2007.
Since 2007, yes. And with a promotion, regular promotion having come in 2008. Now, my lord, annexure at page 24, my lord. 24, my lord. The following incumbent of the Directorate of Mineral Resources, Government of Meghalaya, is hereby confirmed against the post with effect from the date as shown. So he was given confirmation also. His name is at serial number 2, my lord. Serial number 2, and he was given confirmation also.
Yes, as the
My lord. My lord, thereafter, my lord, he came with a writ petition before this Honorable High Court for being considered for being promoted to the next promotional post.
Next promotional post is what, of?
Of chemist.
Okay, chemist.
Chemist. Now, my lord, if I can take your lordship to annexure 9.
Now rules are in place.
Sorry, my lord?
Rules are there now.
Rules? No. Still draft rules. Till now, the rules have not been notified. Draft rules only. Now, my lord, annexure 9, my lord, the judgment.
Yes.
My lord, if your lordship comes to page 60, my lord.
60.
60, my lord.
1 second.
This was
This
the
is WPC number.
This is the WPC number 94 of 2018.
Yes.
Now, my lord, if your lordship is at page 60,
Yes.
my lord, that was in that judgment, my lord. On the last date, that is on so-and-so date, this court, on being apprised about this position, had directed the learned State Counsel for the respondent number 1 to 4 to obtain precise instructions as to whether the petitioner is being considered by the respondents for promotion to the vacant post of chemist, as has been indicated in that letter. Today, so-and-so learned government advocate to this query has referred to that part of the instructions received from the respondent number 1 to 4, wherein eligibility criteria for promotion and names of persons who are to be considered have been given. This note is taken cognizance by this court at this stage, and the eligibility criteria and names of the persons are submitted is reproduced below. So his name is at serial number 3, my lord.
Okay.
Now, para 7, a bare perusal of the eligibility criteria as set out is that promotion from amongst the assistant chemists will include persons who possess BSc chemistry and who have rendered not less than 5 years of continuous service in the post of assistant chemist. On examination of the table showing the names that are to be considered, it appears that from amongst the 3 persons who are serving as assistant chemist, presently the petitioner who appears at serial number 3 is the only one qualified for consideration of promotion, as he has the requisite prescribed qualification as also years of qualifying service. This was a clear finding, my lord. In consideration thereof, and not to further prolong this matter, and keeping in view of the instructions and materials received and produced by the learned GA, without further examining other issues, this petition is disposed of. That with regard to promotion to the post of chemist, as the petitioner is qualified in all respects for consideration thereof, the same is to be taken into account by the respondent number 1 to 4, and his name shall be accordingly considered as and when the Departmental Promotion Committee sits. It is also observed that though the respondents are relying upon the draft service rules, the same is yet to be finalized. It is hoped, therefore, that the same are finalized and notified at the earliest so as to benefit the persons in service in the said department and put an end to avoidable litigation such as has been occasioned in the present case. So this was the judgment, my lord. And thereafter, another writ petition was filed, my lord, in which a time period was fixed of 2 months. And then subsequent thereto, my lord, because the appointment was not made within the period of 2 months, so a contempt petition was filed. So we have annexed the contempt petition. And thereafter, when the contempt proceeding was initiated, my lord, thereafter they came with a reply that the DPC has sat and the DPC has arrived at the findings. Now, my lord, this is the matter of contention before your lordship now. That is at page 80.
Yes.
Page 80, my lord. My lord, if I can take your lordship to page 81, after careful scrutinizing all the papers and service records of the officers concerned, following are the observations of the committee members. So there were 3 for consideration, and the first one, M. Nongrum, for the reasons stated therein, did not recommend his name. So he was not recommended.
Yes.
Now, R.D. Sangma is the second one, Milan. In his case, what happened, he had not been regularized in the post, in the feeding post, Milan. So therefore, they said the committee therefore requested Director of Mineral Resources to regularize the service of Robert Sangma, assistant chemist, first as per government instructions and then come up with proposal to the, Milord, they are doing the whole job, Milord. They are recommending that he is to be regularized, then the proposal is to be put up and he will be taken into consideration. Whole thing is being done by the Departmental Promotion Committee. So, Milord, in my humble submission, Milord, and what the stand we have taken, Milord, this is much beyond the scope of the Departmental Promotion Committee. Milord, they had no business in giving this sort of a recommendation. Now, Milord, third is Andrew Khonglam, this the petitioner here, was initially appointed as laboratory assistant on officiating basis on 10/1/2003 on the recommendation of the Departmental Selection Committee. Subsequently, he was allowed for regular promotion to the post of assistant chemist with a office order number so-and-so dated 22/7/2008 on the basis of recommendation of Departmental Promotion Committee constituted by the Director of Mineral Resources for the purpose. The committee perused all the relevant papers and his service records and observed that since he was initially appointed on officiating basis, he should have been regularized by the Meghalaya Public Service Commission or District Selection Committee, as the case may be, as per the relevant government office memorandum issued by the Personnel and AR Department. Only the Cabinet could approve for regularization of ad hoc appointment. Since his initial appointment is irregular per se, his subsequent promotion also stands irregular. Now, this is a finding of the Departmental Promotion Committee. Hence, the committee decided not to recommend his name for promotion to the post of chemist for the above stated reasons. However, the committee felt that the Director of Mineral Resources should take up his case with the Personnel and AR Department for regularizing his service at the earliest possible. Now, my lord, these minutes of the Promotion Committee, my lord, DPC, this is what is under challenge before your lordships. Now, my lord, this we are saying that this is to be quashed. My lord, firstly, my lord,
what are the grounds?
My lord, as we have said, my lord, that when they were not finding anyone to be qualified. They went much beyond their
brief,
beyond their
mandate.
Parameters, mandate, in recommending that one particular person was to be regularized. Even in our case also, Millard.
I made him a party here.
Who, Millard?
This
R.T. Sangma. R.T. Sangma is not made a party. R.T. Sangma is not made a party. He was not given any benefit as such.
The orders are passed, would it tread on his toes?
Because here it is only that he is to be only recommendation for regularization. There was no effective order given in his favor. He was not recommended for promotion.
Therefore, what is mode of appointment? Oh, you see, read other party. However, base candidate, he has been recommended. That means he was recommended by a general cabinet approval.
Yes.
That happened in March 22.
Yes,
It is not very clear here, Millard.
So it's not very clear. So the thing is that, are you trying to say that he has been regularized from initial appointments been regularized? That his promotional appointment was not regularized. Then why should a DPC stretch the neck to say that okay, now regularize him?
for regularization.
Millard.
Then you should do the same thing for the.
That is what we have done for Andrew H. Konglam also.
Millard, for Konglam, Millard.
We have said that
now,
it has not been regularized by the cabinet, which is why it should be sent to the cabinet for regularization.
Not to the cabinet, yes.
That is
Millard.
nothing.
Millard, in DPC, Millard, how they go into recommending so-and-so to be regularized, so-and-so not to be regularized and all that. This is much beyond the mandate, Millard. This is not a task of the DPC at all. Secondly, Millard, the second point, eligibility of the persons who are to be considered. Persons have been sent for consideration, Millard. The department has found them to be eligible. That is why they have been sent up for being considered by the Departmental Promotion Committee. Now the Departmental Promotion Committee goes behind that. Now, where does it get the mandate to do so, Millard? How can the Departmental Promotion Committee go behind the eligibility of the persons who have been sent up for being considered?
No, they can consider it.
They can do that.
They can say, even if only one person also goes, is found unfit, they can.
My lord, point is that the persons who have been sent up, Millard.
Yes.
Anyway, Millard, my humble submission, Millard, that it is beyond their mandate, Millard. Now, Millard.
One thing, you see, there are two aspects. Now, if you talk about these kind of matters, where people are put up for selection or promotion, there's a screening committee and there's a DPC. They're two different. Even a person's screening committee his own name might appear in the list for because of promotion. That doesn't mean that'll be vitiated. The screening process.
Now, Millard. Now, what is this? What are they saying against Andrew Konglam, Millard? And they are saying that he was initially appointed on officiating basis.
This is the aberration. How we address this, Mr. Roti?
My lord. Now, my lord.
Because now, how can you confirm a person in service? It's their mistake. They have to regularize the service.
My lord, what they are saying,
incumbent upon
what they are saying is that when he was appointed as a lab assistant, he was not regularized. Then he was given a promotion. Then in that promotional post,
he was regularized the promotion post.
He was regularized. Now,
I've seen that. Yes.
Let me finish.
Yes.
After that you will come. Let me finish. After that you will come.
Just clarify.
So, Willard, this officiating post, he was initially in an officiating post, and thereafter he was regularized in that promotional post. Now, your lordship has seen, Millard, that the DPC sat, a regular process was followed, he was regularized. Now, Millard, my submission is this, Millard. Yes. My submission is this. He has been confirmed in the service, Millard. He has been confirmed in the service. And he has been allowed to proceed altogether, my lord. Now, in the initial post when he was given, whether he was confirmed in that or not, how can that be relevant, my lord?
Well, it is relevant.
It
is relevant because when you enter, it's the initial appointment, which the baseline for these kind of cases is what is your mode of initial appointment. That's the baseline, and if it's against a sanctioned post or regular vacancy.
All that is the question.
Then, yeah, it's all that. So you have there are certain parameters which like which myself in dealing with matters I've devised. What are the baselines? So you look at that, then the passing judgment becomes easy also. Mode of appointment, and is in your case there has been serious lapses on the part of the state respondents. They have to correct that. So that's we look at the baseline. Mode of appointment. Is against sanctioned post. He's paid regular scale, but given all the benefits of regular employment. So only thing that remains is that formality of him being, being given that status of initial regular appointment. That's all.
So, my lord, now the question arises. That means, my lord, that means the question arises that his subsequent confirmation to the post, regularization and confirmation which took place, my lord, that is being reopened.
No.
My lord, because if the first.
But the first one has records have been set straight.
My lord, for the sake of records is a different thing, my lord. But
once for the sake of records,
that cannot be reopened.
Vests you with the right for career progression, Mr. Kurati.
My lord.
That once that is corrected, then that puts everything in line.
So
they cannot deny you if you are eligible qualified to have it. There can be no denial. They can deny you some other reasons maybe, but on questions of qualifying service.
My lord, my submission, my lord, here, if we go by what your lordship is, what is falling from your lordship's mouth, my lord, in that case, my lord, his subsequent regularization and confirmation, that is being opened up, my lord, again, because, my lord, if they do not regularize now,
they have to regularize.
So, my lord, they have to. That means it is as good as the assumption is that regularized.
Yes.
My lord, when we say that they have to regularize, that is as good as regularized.
No.
So on that issue,
court cannot give the directions for, we can give them directions. They will do it. This is not the only case, Mr. has come before this court. This kind of case.
My lord, my submission here, my lord, my submission is that this whole recommendation of the promotion of the Department.
Okay, no, forget the DPC part. DPC part, whatever is.
But the DPC is going into that, my lord. When initially, as your lordship has seen, my lord, earlier there were submissions made before this honourable
They will have
court.
a review DPC after they let them. Will direct for review DPC after they make the records straight. That's all. If they feel the records are not in proper form, let them make the records
Because,
straight.
my lord, in that case, my lord, your lordship will give an observation that subsequent confirmation and regularization, that cannot be touched, my lord.
No, that cannot be touched.
That,
how will you
that
touch
observation should
How
fall
will you
from
touch
your
a
lordship.
confirmation?
That observation may come from your lordship. If that
There
observation...
are cases have come here, people have been confirmed in service, they have retired, and then when the time comes for the pension, they say that they were not regularized when they appointed as, as a beyond that time, we retired means UDA, LDA. That is the kind of lapses on the part of the respondents.
Essentially, they have lapses on their part, my lord. But now
if they found you fit to promote you, they found you fit to give you a promotion, to regularize that promotion, to confirm you in service. What remains?
So, my lord, if your lordship goes in that line, my lord, my only submission is that your lordship will protect the subsequent confirmation and promotion, my lord.
Yes, of course. That is a given. We're not going to allow you.
And if your lordship fixes a time.
Because the recommendation of the DPC is very clear that he should be his name should be sent.
Now let's hear what the
regularization.
EAG has to say. Yes.
No, your lordship.
What
your lordship has said.
I should have expressed my mind so much, but anything. But in these things, that's how you correct it.
There has been when he was promoted in an officiating capacity as an assistant chemist, there was some lapses on the part of the department, your lordship. But then, your lordship, now that the DPC, while opening the books, the documents and all that, your lordship, when they were sitting for promotion, and on finding that there has been, that this man was only in an had been appointed in an officiating capacity initially, that he should be regularized. It's just for, like your lordship had said, it's for the purpose of keeping the record straight, Your Lordship. Once the record is straight, Your Lordship, then his promotion, and if he is eligible, then his promotion can be considered along with the others who are also eligible.
Whoever becomes eligible,
Yes,
whatever it
Your
is, yes, of course. But then you have to have a review DPC.
But the DPC, Your Lordship, as my friend had taken many grounds, Your Lordship, that the DPC was not properly constituted as per rules, which is absolutely wrong, Your Lordship.
Not considered as per rules.
That is what is his contention.
Where's the allegation made?
That
It's
it-
not
but-
as per rules.
I did
In
not
the
press.
writ
I did
petition-
not press that.
He did not press, but it was constituted as per rules. We have stated in our affidavit
If you
also.
say there are no rules, then what rules?
No, as per rules of this draft rules, Your Lordship. Draft
We're
rules.
not going to pay heed to draft rules. Those are just.
Anyway, Your Lordship, but we are going by that as of now, Your Lordship.
You say DPC.
Till such time that the final rules are finalized, settled, Your Lordship. Your Lordship, in this matter, Your Lordship, I have also got some citations
Very good.
regarding the
Yes.
DPC's role, whether they
Yes,
can go.
that's important. Let's see.
Yes, whether they can go into
beyond.
the. I've just given some bullet points also, Your Lordship, so that to keep the things straight. That's just 2 citations.
Any authorities from your side, Mr. Vati, regarding entitlements of the petitioner?
The DPC can go ahead, Your Lordship, and look into, it is not bound by classification or anything. They can look into other matters also, Your Lordship.
Which paragraphs? In this other one,
Which one,
18,
Your
15?
Lordship?
This was one, UPSC versus.
This is Union Public Service
Satya
Commission
Priya.
versus Satya Priya, 2018. SCC, paragraphs 17, 21, 22, and 23, Your Lordship.
17.
21, 22, and 23, Your Lordship.
Yes.
And in the other one,
Let's see paragraphs 17. Have you given a citation to?
no, I'll give him, Your Lordship.
Yes.
Just take the go through the citations first. I'll give you the copies. The selection committee consists of experts, 802.
Yes, Ike Narula case, that's
Yes.
very famous.
Yes, sir. Yes, Your
Yes.
Lordship. And it is a set, and 18, Your Lordship, it says that it is settled legal proposition that the court have to show deference and consideration to the recommendations of the expert committee consisting of members.
Okay, next decision.
The next decision is Muhammad Mustafa versus Union of India, 2022 SCC, page 294, Your Lordship.
HS Sidhu.
Paragraphs-
Muhammad Mustafa.
Yes, Your Lordship.
Paragraphs
Paragraphs 15, 18, and 36.
15, 18, and 36. Okay.
May I read, Your Lordship, or is it okay?
We'll just have a look, yes. Whether it's applicable or not, that's one. It's a general. It's a general.
Everything, Your Lordship. And the other one is HS Sidhu, 2016 SCC, page 495.
And that's paragraph.
Paragraph 13 is the main thing, Your Lordship. Main paragraph. It needs no special emphasis to state that while exercising power under 2 to 6 of the Constitution, the High Court cannot sit and appeal over the assessment made by the TPC. It has been stated that if the assessment made by the TPC is perverse, if it is biased, yes, Your Lordship can
Well,
interfere.
we should malafide is bias also, yes.
Yes, if there is malafide, any malice or malafide.
Anything else?
then-
Mrs. Horti, any authorities you want to rely upon? No. Yes. You pass order today itself. You want to pass and put, man.
My only request would be that to protect his present position.
we have to, of course, this is.
And if your lordship deems it fit to fix time frame.
No, we'll ask for, this is what the court observed, maybe he'll call for a review DPC, that's it, after they set the record straight.
23 time, when the cabinet will sign.
Yes.
Largely.
Is it that now? 23. No, it was affidavits and all that. filed by them. We please your lordship. Now, my lord, here, my lord, the petitioner is the association or the pensioners association, my lord. Now, my lord, in my respectful submission, my lord, here the matter being agitated before your lordship, that is equally for all members of the association. I mean, all pensioners. It's not a specific.
But many pensions have come individually.
Yes, they
some
have come.
have been paid, some haven't.
That is it.
The lordship has passed the order giving time to the government.
Yes.
I mean, excuse me. Courtmaster. So payments are being made in terms of the order.
Is your these 648 names are part of your association?
All are part.
Then what remains to adjudicate here?
Now, my lord. My lord, our case here is absolutely different from the case of the individuals who had come before your lordship.
Yes.
My lord, we have come before your lordship with a submission that, my lord, the stand taken by MECL that there is lack of fund, that is not correct. That we are challenging, assailing, my lord, because there is an understanding when the MECL was formed under the 2003 Act and the MESCB was done away with, my lord. At that time, the government was under a commitment to the MECL to tide it out, to tide out the organization from financial constraints. So, my lord, we are saying that that commitment of the government was never fulfilled, nor probably the MECL also has not pursued the matter, my lord. Now, even the amount, my lord, which was committed at that time, that is also there, my lord. It was about 804 crores as per the thing, my lord. So, my lord, and it included pensionary benefits and retirement benefits and all that. That time grant which would be given by the government to the MECL for tiding over all those.
Has never been given.
That was never given, my lord.
But
So, my lord, why is that not
What is your
pursued?
role then to, how can we issue a mandamus to compel the state?
No, my lord, not a mandamus to the. I am not asking for that. In my prayer, it is not there, my lord. I am just saying that this shows that MECL stand that they do not have financial ability. Financial constraints are there. That is not correct. That is not correct, and therefore a direction is to be given to the MECL to release the
to state government.
No, my lord, we are asking for a direction
Yes,
against
you said that
MCL.
they have not got the money from state government.
My lord, that we have shown before your lordship to establish that the MECL is not in shortage of money. They have the resources because they have to pursue with the state government to get the money, and with that money they can easily clear.
As you're pursuing from them, you put them in the same position that they will pursue from state government.
Well, our submission is that they should have pursued. They should have pursued, they never pursued. And they are saying they are in financial constraint. How can that be? When resources are there, when the state government, this is
Where's the agreement you said where they send MOU?
Annexure 3 is the scheme, Millard. Another continuation of that at page 24, Millard. There is a memorandum of understanding.
(2010).
2010 million. 31/3/2010.
Where it says 804 crores.
Millard, if you're if your lordship comes to page 29, Millard, liability in respect of existing pensioners and all that is covered, Millard. Millard, at page 32, Millard, if your lordship comes, Millard, the following table summarizes at page 32, Millard.
Yes.
Transitional support for Government of Meghalaya on account of the financial restructuring. So, Millard, here it is a total of 709 crores is there, Millard. This was the committed amount, Millard, at that time for the financial restructuring, Millard.
So that's about it.
That, Millard, a note on the assistance of 840, Millard, at page 35, there is a note, Millard, official note, where the actual amount has been quantified at 840.04. Now, Millard, these amounts and all are not relevant, Millard. What is relevant is that the government of Meghalaya had committed to bring the MECL out of its financial
You are
distress.
paying for the MEC or you are paying for the government? In this.
My lord, I am representing all the parties, my lord, and I will answer issues one by one, my lord.
Then like page 35, the note.
Now, 35, Millard, this note on the assistant, this brings out the actuarial.
Office memo or is it a public document?
It's of the office only, Millard, if I am not wrong. Nothing secret about it. So, Millard, our submissions, these we have.
Whether they are bound by it.
These we have brought out, Millard. These we have brought before your lordship only to indicate that there was a commitment from the government of financial support to MECL and which has not been lived up to. It has not been completed. The process has not been completed till now. And so, Millard, the MECL is in a position to generate the financial resources to complete payment of the pension and whatever retirement benefits of the pensioners as existing. So, Millard, they stand taken by them that they are at financial distress and unable to, that stand is challenged.
What is this punish? Okay, sorry. Next year 5.
Next year 5 million.
Oh no, is your letter, sorry.
These are communications, my lord, between the association and the MCL.
And page 40?
40, my lord. My lord, these are the persons who died in service, my lord. Their list has been given. At the time of when this was filed, my lord, who had died in service and the dues outstanding to them. And then the next page, the pensions. So, my lord, the difference with the other cases which were before your lordship and this instant case is that here we are basically pointing out that the MECL is in a position to generate the money. That is our basic submission.
Yes.
Yes, my lord. My lord, kindly see the prayer, my lord.
Yes.
Direction is, my lord, for disbursal of pension, my lord. Page 9 is the prayer, my lord. Disbursal of pension. So far as this prayer is concerned, my lord, in view of your lordship's order, in my humble submission, prayer does not survive, my lord.
Yes.
Your lordship has given a time frame to MECL to make the payment, and the authorities are trying to release the payment. Now, my lord, the second contention which has been raised is, my lord, that there is a note, and in note some promise has been made by state government which is not being fulfilled, my lord. Now, my lord, the writ petitioner has also annexed Annexure 3, my lord, the transfer scheme. And transfer scheme is a statutory scheme which contains the entire scheme of transfer, my lord. Kindly see page 14, the transfer scheme, my lord. Because this is a statutory scheme under which liabilities, obligations, everything have been crystallized, my lord. And that transfer scheme your lordship will find at page 14.
Yes.
And the relevant scheme, my lord, your lordship will find at 6, my lord. Transfer and deputation of personnel at page 19. On such transfer, my lord, and subject to provisions of the Act and other provisions of this scheme, and personnel shall form part of services of MEPDCL, MEPGCL and MEPDCL as the case may be, but their rank, scale of pay and interstate seniority as existing in the board on the effective date of transfer shall be maintained in holding company, and retirement benefit and other benefits shall in no way be reduced than one existing in the board on the effective date of transfer, my lord. So this is the right, my lord, which is there given in the transfer scheme, my lord, that this transfer scheme, my lord. Then the next one is, my lord, 5, my lord. Notwithstanding the provisions nature of transfer of personnel in MECL and a further deputed so and so, as per so and so, personnel shall discharge their duties and function as may be assigned to them from time to time to MEPDCL as the case may be, and MEPDCL and shall have power to exercise all administrative and disciplinary control over personnel transfer to this power, my lord. Now, benefits, my lord. C, if your lordship will see 6C. The transfer and further deputation of persons shall be subject to following. So this is, my lord, 6A, my lord. C, my lord, all benefits of service accrued before the said date shall be fully recognized and taken into account for the purpose including payment of terminal benefit. E, my lord, subject to scheme, personnel shall cease to be in service of board and shall not assert any claim and any benefit service under the state government, my lord.
Yes.
Then at the foot of the page, my lord, of page 29, small Roman
29.
9, page 20, small regulation 9 and small Roman 2, my lord. MECL shall be responsible to ensure terminal benefit trust, including pension, gratuity, leave encashment of the board, and progressively funded in regard to unfunded. So MECL is, my lord, liable, my lord, under the pension, etc. Everything is to be done by the under the scheme, my lord. And 10, your lordship will kindly see 10. All obligation in respect of pension, gratuity, leave encashment who have retired from service of the board before effective date of transfer shall be discharged by MECL, my lord. So the scheme, my lord, kindly come back to page the page 14, my lord. And the preamble of the scheme, my lord, in exercise of power conferred under section 131 and 133 and other applicable provisions of Electricity Act 2003, state government hereby makes the following scheme, my lord. So the scheme is statutory scheme. It binds the party. It binds the state government, my lord, and the parties are governed by the scheme, whether MECL or state government. No person has the authority to go beyond the scheme, my lord. Therefore, reliance on a note, in my humble submission, is misplaced, my lord, because that does not give any right. And note also, your lordship has taken note that there is no clarity that this is note are internal discussions between the parties, and they do not as such confer the right on the basis of note, my lord. This is my third submission. Page 35, where note is annexed, my lord.
Yes.
Fourth, my lord, time to time state government has been giving the grant also. Time to time it has been there. Whatever is feasible within the scheme of thing, my lord, the state government has been providing the fund. It is not that the state government is not extending the help to the MECL, my lord. Last but not the least, my lord, this petition has been filed by association, and it is in the nature of PIL, my lord, and the PIL is not maintainable in service matter, my lord. Your lordship, I have got a caten of authorities on this. At this,
that's why they filed a petition.
Yes, my lord. And the individuals have already filed their petition, my lord, and their grievances have already been satisfied by your lordship's order, my lord. So therefore, for the same cause of action, they can't maintain the second petition, my lord. And it was initially part of the.
Can they say that it's an action on your part to secure the 840 crores, which is it's like a bridge loan? It's like a bridge.
It was a part. My lord, it was a part of
one-time measure. It's a one-time measure to put you on your feet.
My lord, your lordship has rightly put the question whether writ of mandamus would lie for.
No, it will not lie. I mean, I'm just
and time to time, my lord, these are the financial matters where in these policy matters where a scheme has come into existence.
That's not acted upon.
And that is being acted upon, my lord, and time to time grant. So therefore, this petition is also not different from the other petitions, my lord. This is all I have to submit.
Only one aspect, my lord. The interest may be directed to pay the interest also.
Whatever do you see, gratuity is a matter of right, and like the Payment Gratuity Act itself provides interest be paid. That is don't need orders of the court, It's only on the quantum maybe. So that is, yes.
Right.
We'll pass orders. I won't reserve it. We'll pass it in a day or two if necessary.
Madam.
28.
Lordship, please, Lordship, for the respondent number 6, Lordship, due to some urgency of matter, counsel for the respondent number 6 have to live out of town. So, kindly allow us to take the matter after lunch.
Who's number 6?
EPF.
Is for EPF? Does matter EPF matter? Napoleon?
Yes, my lord.
What's Napoleon doing with EPF matter?
Oh, my lord, he's the head of the association, my lord.
Which association? Where's the petitioner?
He's a trade union, my lord. He's a president of the trade union. Name is RBPPWU.
This is also like a PIL.
No, my lord, it is directly represented, my lord.
So you look at a prayer. You file is that for sales benefits? Just for you're asking for implementation of a socially beneficial legislation with regard to muster roll. What else? Officiating employees, contractual, casual.
Yes, my lord. I'm representing some of the.
I understand, but that's like a PIL. You're asking for that they should be given the benefits of Provident Fund.
Yes, my lord. That's.
So, if file a PIL.
My lord, specifically, I have come with
Where are the names of the persons? In petition, 3 pages.
My lord, in my rejoinder, my lord. In my rejoinder, my lord, I have given the list of the.
No, that's regarding your association.
Association, I have given the certificate, my lord.
Yes. Have you settled a petition? What is how EPF to be applied in such cases? Because how Provident Fund will be attracted, applicable in the case of. Have you named the people who would be affected?
Yes, my lord. I have given the in my rejoinder affidavit, and also in my additional affidavit, where I have submitted the certificate as well as the authority, my lord.
Boy Progressive PLD Workers Union.
Yes, my lord.
What is your union?
It's a registered union.
No, fine. I'm talking. You come by union is fine, but it's just a umbrella prayer with everybody in the state.
Not my lord. In the Department of PWD, my lord, specifically.
All the workers in PWD.
Yes,
in the state.
Yes, my lord.
This progressive belongs to whom? Is there some persons behind it? Progressive hawkers, progressive workers.
It's an union has been created by the laborers of that particular department.
Is it affiliated to any other trade union?
No, my lord.
Like what's that? INTUC or?
No, my lord. Not affiliated.
Or what's that? Left, right, center.
Right.
Many of them.
Yes, no, not my lord.
This is left.
No, this is neither left nor right, my lord. This is correct. They are just following the.
Not left.
Not left, my lord. It's not affiliated to any political thoughts, my lord.
Boy Progressive PD. Okay. What do they say in the affidavit?
They are contending that the state contending that it's not applied to EPF is not applied to the department employees of the department. That is their our stand is, my lord, that since they are the casual laborer appointed and employed by the department, though they are not directly entitled to get the EPF or any provident fund facility schemes from the government or as regular employees, they are entitled to get, my lord, as per Section 3 of the EPF Act, my lord.
I get Provident Fund Act.
This is Central Act, my lord, is 1952.
Well, one thing, Mr. Nanda, how do you say that? How do you get what do you call it? How will you bypass the embargo of the Act, since they are employees under the state government?
My lord, they have been employed as a casual worker, my lord.
RCWs also?
Yes, PW. My lord, through the PWD.
See, if you file a petition, if you want, because this is not a question of private employment or employment, this is employment under the state, correct? Employment under the state, an embargo is there with regard to, I think, cooperative societies. Then if it's an establishment under the state government where employees are paid dues to state government and maybe entitled to other kind of benefits, so the Act will not apply. This Act mostly applies to people in an organized sector who have no security with regard to employment, so that they be like employee state insurance, then employee provident fund. So it's a social beneficial legislation,
yes,
which gives safeguards their interest as workers or as employees.
Correct.
Right.
Exactly.
So now embargoes that you know very well, that will not apply to establishments under the state or central government. How do you get around that? How do you get
yes,
now have you, that is one thing, your writ petition is very,
yes,
writ petition is 3 pages.
Yes, my lord.
So from the writ petition, from your pleadings there, from the pleadings here, let us see your pleadings. Where have you written that the embargo of the Act, that the Act will apply? Why? Where?
My lord, here.
Where have you said, which paragraph you said that, that the Act has stipulated like this, though they are workers working under the state government and paid by the state exchequer.
No, this is not paid by the state. It's not like this,
It's
my
not
lord.
paid by the state. Are regular casual workers not paid by the state?
My lord, it's not like this.
What is like this then?
Since last 30 years, they are being employed for the purpose of all manual work, casual work. Now this payment.
Mr. Nath, you're coming with a writ petition before this. It's and you're seeking invocation of 226. Now
Yes.
at least if your petition is a 3-page petition.
The salary, my lord. This salary has been paid, my lord. The wages have been paid by the PWD department, my lord.
Then PWD department is what?
It's
a private entity.
No, it's a state government.
Then?
It's a state government, but here is a difference, my lord, as per the definition of the employee, my lord. Here, in regard to the EPF, my lord, in regard to the provident one.
Petition just now, that's fine. It's very easy just to come with a petition, say with trade union, you give us the benefits, but you have to satisfy, you have to come by the requirements of law that that embargo not apply to these people who have come under the umbrella of your trade union.
This my lord, I have given in the.
See, you just write the petition states office executive engineer, public works, Nongpo, regularly employing casual workers, muscle workers, officing staff, some group D post, aero contractual, daily fixed salary. Based on this, a department presently is employed casual workers. That petition states casual muster roll laborers, officing are primarily engaged in tasks like roadside grass cutting, cleanings, other casual works. Then the muster roll are being paid varying amounts of 12, 17,000, so and so. That employment is an important labor welfare which is introduced to help employees working under the government public. I don't want to make these observations, but at least a petition should disclose something which can be adjudicated. You don't want to dismiss it in limine.
But here
this court feels inclined to do it.
My lord, here it's.
Where have you quoted the Act also in your petition to say why they'll come under the exceptions?
My lord, paragraph 12, my lord. Paragraph 12, my lord.
Where we said that special state after removal from service, these employees who suffer immense difficulties to maintain their day-to-day life for being loss of earning and security, for not having provided the benefits of employees' provident fund and a bit. That is what how do you say they have to be paid that? See first, put it down here. This provision like this, section so and so says this, that that there is an embargo on state and government, establishment state and government.
This statement is
I don't know, better you withdraw it and craft it properly, or we will dismiss it. Three-page difficult petition.
Well, I'll just take the instruction.
What instructions will take?
Oh,
you can't. We have to go by the pleadings made in your petition. Otherwise, we'll dismiss it, Mr. Nath.
Well,
we'll dismiss it. I think we'll pass an order. We just say that the petition doesn't, the pleadings don't disclose in which manner the petitioners are entitled to, as they're already serving under the state government establishments, which is as per section.
I'll file a fresh.
Yes.
Allow me to file a fresh, my lord. I will do it.
You'll withdraw. Yes, after hearing at some length, Mr. Echanat submits he may, due to the sketchy pleadings, may be allowed to withdraw this application with liberty to file a fresh. Prayers allowed. Matter stands as both of withdrawal as with deputy as prayed. Yes.
29.
Today it seems it's Mr. Chakravarti's day. Well, you say I'll have my day in court.
I don't know why all the matters are listed on the same day.
It is Mr. Lalu's fault. He's asked for the adjournment because you are away on certain dates, that's why. Make sure senior is available to do all the game in one shot. Yes.
My lord, here, my lord.
Yes.
If your lordship pleases. My lord, the petitioner is a professor in the.
He's a full professor.
He's a full professor. Now, my lord, a departmental proceeding has been initiated against him.
What's the matter about?
My lord, here one of the juniors, not junior, the scholars under him, she wanted a change of guide.
Oh, you're challenging the department proceedings?
My lord, my lord.
What is the stage? Is over?
Instruction I have received, but we have initiated, memo of charges has been issued. Now he is required to file his written statement. Law is very clear, my lord, a certain period has to be filed. The instruction I have received till late, he has not filed the written.
Why not taking part, Mr. Chakravarti?
My lord.
Internal inquiry, court will not interfere. Only his.
My lord, here, my lord, what we are saying is that, my lord, the charges are not made out at all in the memo which has been memo and the annexed documents which have been issued, my lord. Your lordship comes to peace.
Yes.
My lord, at page 23, my lord, your lordship is on the memo, my lord, annexure 3.
Yes.
My lord.
Yes. Pursuant to so-and-so? Yes.
My lord, if I can take your lordship through this memorandum, my lord.
Yes.
pursuant to the decisions.
Yes.
Pursuant to the decision of the 187 and 188 EC, Executive Council, and acceptance of ICC report, the Vice Chancellor on behalf of the EC proposes to hold an inquiry against Professor P.S. Suresh under the Rule 14 of the CCA rules on the matter of misconduct committed by him while functioning as an employee of NEHU. The substance of imputations of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charges. A statement of the imputations of misconduct or misbehavior in support of each article of charge is enclosed as Annexure 2. List of documents by which and a list of witnesses by whom the articles are at Annexure 3 and 4, Milord. Now, Milord, next page, Milord, and page 24 is the statement of articles of charges.
This memorandum is, what is it? Is it?
It is dated 27 September 2020.
This is the memorandum is a decision. No, conveying decision.
Conveying the.
Okay. Of the Executive Council.
Matter. Now, my Lord, statement of articles of charges framed against P.S. Suresh. That is at page 24, my Lord.
Yes.
Now, my Lord, that the said Professor so-and-so, Department of Economics, Shillong, while functioning as such, committed an act of sexual harassment to the female research scholar of the said department who is under his supervision. By his act, Professor Suresh, as an employee of the university, has committed a serious misconduct in gross violation of the provisions of 3.1 of the CCS conduct rules, which require every government servant at all times to maintain absolute integrity, to maintain devotion to duty, and do nothing which is unbecoming of a government servant. The above act of Professor P.S. Suresh calls for imposition of major penalty. Now, my Lord, here there is just a vague allegation that he had committed an act of sexual harassment, nothing more than that, in the articles of charges. Now, that should have been expanded in the statement of imputation. Now, statement of imputation is at page 25, my Lord. That the said so-and-so Department of Economics, Shillong, while functioning, committed an act of sexual harassment to a female research scholar of the said department who is under his supervision. The above act is grossly immoral, outrageous to the modesty of the female research scholar, and highly detrimental. What is the act, my Lord? Act, nothing is stated here.
Such matters, I don't think they will like to.
Anyway, my Lord, that at least whether there was any physical contact, whether there was any, nothing at all is there, my Lord. And that internal complaints committee, the report of that also has not been annexed to this. What is the finding of the internal complaints committee? That also we do not know, my Lord. Highly detrimental to the conducive and congenial academic atmosphere for academic pursuit of the female students, research scholars. Now, my Lord, there is hardly any difference between the statement of articles of charges and the statement of imputation of misconduct.
Now, one thing, Mr. Chaudhary, just come to Annexure 3. They would have provided all these documents.
My Lord?
Provided, then you'll know from there.
My Lord, Annexure 3, my Lord, the list of documents, my Lord, and the list of witnesses was never provided to us. That we have mentioned in our thing. It was never provided. Now, my Lord, list of documents, my Lord, whatever is annexed here with my Lord. Now, my Lord, how the whole, how it holds, the whole thing starts. That is at Annexure 6, my Lord, at page 27. This is handwritten, and 28 is the typed copy, my Lord. Typed copy is at page 28, my Lord. I, so-and-so, PhD first year student of the Department of Economics, working under the supervision of so-and-so, would like to report an incident against my supervisor that I am facing sexual and mental harassment from my guide. Even after warning him so many times, he has been sending messages which is not at all acceptable for me, and I am not comfortable to work under him anymore. I am afraid if it comes out, he will put pressure on me. So kindly request you to change my supervisor. Milord, the only request here is change of supervisor. And she says that she is not comfortable in the communications which are taking place. Now, my lord, the head of the Department of Economics, what he does, on the basis of that, he writes to the Vice Chancellor and converts it into a complaint. Here, my lord, the only request is to change the supervisor as soon as possible. Only that much. And he, the head of the department, writes to the Vice Chancellor and converts it into a complaint. Milord, I'll just take your lordship to this page 29, Milord. I have received a verbal and written complaint from one of my newly admitted female research scholar of the department accusing one of the colleagues of the department, who also happens to be the allotted supervisor for her PhD program, of mental and sexual harassment against her. The student met me on the afternoon of 31st of May at my chamber and narrated her side of the story along with a request for change of supervisor. She is traumatized by this experience and is apprehensive of the future of her research program if he continues as her supervisor. While the department will take necessary steps to change her supervisor, I am bringing the complaint to your kind attention and direction, as it is a serious matter concerning an alleged sexual harassment by a teacher of the department. I shall reveal the particular of the case to you personally, as the student has requested to protect her identity, so that the alleged perpetrator, who is in a higher position, will not take any adverse action against her in future. Now, my lord, this is all that has been submitted to, that has been provided, my lord, and together with it, there is a voluminous, my lord, these, what are these? Conversation, WhatsApp conversation, voluminous, my lord, between the teacher and the student.
They were part of the documents that was supplied to you.
Supplied, my lord. They were part of. That's why we have brought it. Otherwise, we would not have really brought this before your lordships. So, my lord, in my humble, respectful submission, my lord, there was. This is over a period of 3 months, I think. That this, starting from 13/3/2023, and the last one is.
I remember this case now because it asked for the private, the name would be struck off because you can't.
Your lordship, director.
Yes.
Director,
yes, you cannot name in such cases. Yes.
My lord, the till 3rd of May. Oh, here to the last.
So what,
till
law,
4th of
just
May.
Give submissions on law. Why do you say that the drawing of the department is bad in law? Just one submission.
My lord, yes, my lord. That is what.
We will not go into whatever. No? You're
All
saying that it's incompetent and it's not sustainable. Whatever. Why is it? Why is the DP incompetent?
My lord, because no offence is disclosed.
Okay, no offence.
No offence is disclosed. No offensive act by the petitioner has been disclosed. Neither in the statement of articles of charges, nor in the statement of imputation of misconduct, nor in the supporting documents.
Okay.
There is just everywhere a generalized term used, sexual, in that sending sexual messages. That is what the letter says. And in the professor, that head of the department's letter, he uses the term sexual harassment. But actual incident, what has happened?
Sexual harassment now, the Vishaka guidelines are there.
Malad,
ICC,
Milord, Vishaka guidelines, ICC, the internal complaints committee.
Yes, I mean,
now, my lord,
what
internal
will constitute sexual harassment also? Now, court sitting here will not go into that, that aspect. I think that once an inquiry, then if you agree, that means that it doesn't mean that there's been any finding against you as yet. It's at a very initial stage.
My lord, this is comparable with whether a case is made out in an FIR or not, my lord.
I don't think it's like for quashing of an FIR.
My lord, it is similar to that in the sense, my lord, that the prima facie no case is made out against him. That is our submission before your lordship, my lord. If there had been even the ICC report also has not been relied upon, my lord. ICC internal
you took part in internal complaints committee.
We took part, my lord.
You were examined by them,
my lord. But the report of that has not been made known to me till now, my lord. Even in this,
they won't that is anyway. That's a different.
That is different. But anyway, my lord, they have not relied on that here also. If the internal complaints committee had come to some factual findings, maybe they could have relied on that, my lord. But they have not relied. So, my lord, whatever be the findings of the internal complaints committee, that is also not in the picture. So, only what is there before your lordship in this, only this is
allegation,
statement of
imputation and documents.
Documents.
Yes, Mr. Sen.
Our respectful submission is this only, my lord, that nothing is made out against him, and as such there is no meaning. There is no logic or reason for this inquiry to proceed.
Continue.
Obliged.
Yes. Yes.
Your lordships. No, my lord, this is a case, my lord, of sexual harassment, my lord. Lordship, this transcript, my lord. But this speaks in volumes, your lordships. We cannot sit over it, my lord, silently. If I can take, my lord, just to one page 59, my lord. Just lordship come to page
50. You file affidavit?
Sorry, 39, I filed affidavit. Page 39, my lord. Page 39, my lord. Second line, my lord. The transcript of the conversation. Well, I will not read it out. Once, my lord, that extent, your lordships, my lord. University cannot sit over it, your lordship, silently. Now, the things, this has been brought to the notice, though she made a request for change of headship, but she said the trauma she has faced. And your lordship is fully aware, my lord, that Vishaka case and all. This is not, if it has come to the notice of any official or authority of the university, his duty, my lord, to initiate action. So this has ultimately gone to ICC Internal Complaint Committee. They have made their recommendations. Now the proceeding has started. Now he may have problem. Now I have categorically stated in my affidavit, whatever required, all have been supplied to him. Now still he has problem that this is vague. My humble submission, these are not vague, clear, categorical, my lord, stands out. Now, still he has problem, my lord. He can participate and he can raise his objection in the departmental proceedings. Now, my lord, the unfortunate part, my lord, taking the plea that the matter is pending, till date he has not filed his written statement. So my humble submission, my lord, this is not a case, my lord, at this stage your lordship will interfere with the proceeding initially. He will get the fair opportunity, my lord, he will participate.
No, Mr. Chawati said that it's like, anyway, it's like, it's equivalent to quashing a FIR.
Exactly, my lord. At this can it be without, my lord, just we have issued my lord, whatever.
Yes. Obliged.
Obliged.
But judgment reserved, yes.
It is the last case.